Audio.
Good morning, Your Honors. My name is Alam Michael Isaac on behalf of the petitioner, Michael Molitor.
That's great. I know you're working. And Attorney Jones, if I could hear you two to make sure we're all technologically signed in.
Good morning, Your Honor. This is Ilana.
Wonderful. We have both lawyers that the panel can actually hear their presentation this morning. We have another panel before you that's in cyberspace or whatever they call it to get the tech out. Okay. And Mr. Isaac, as an aside, I'm not upset at all about your Rays jersey. And I was wondering if the one to the right in red was the Atlanta Hawks, but I couldn't tell when I was checking in earlier this morning. But I'm okay. And the other one seems to be LeBron James, if I had to guess the number 6.
It is, Judge, and the red one is a Houston Rockets. It is Tracy McGrady. I've got a Kobe Bryant that you can't see and all sorts of others throughout my office.
Well, it certainly is better some of them on the other backdrops I'm seeing. So for my sake, I'm not bothered. I'm not troubled.
Apologize. So
Don't be. We're good. We're so glad to have both of you today ready to go. I think I speak for the panel. We're excited. And counsel, did you wish to reserve any time for rebuttal?
5 minutes, please, Your Honor.
I will be your timekeeper today, and I will do my best to give you your notice as you get there. And with that, we are ready to begin. Please go ahead, counsel.
May it please the court. I'll reintroduce myself. My name's Ilham Michael Isaac. I represent the petitioner, Michael Moliterno. We are here before the court in second-tier certiorari. It is our contention that the circuit court misinterpreted Florida statute 322.28. Certainly a misinterpretation of a statute would be the application of the wrong law and would entitle us to relief under second-tier certiorari. As I see this case, it is one of pure statutory construction. Depending upon where the questions go, we may go down a few rabbit holes, but I see the case actually as fairly simplistic. Whether an out-of-state conviction as the triggering conviction, that's an important vernacular, as a triggering conviction for a suspension is governed under Florida statute 322.28 subsection 1 or Florida statute 322.28 subsection 2. That's as simple as it gets. And I think it's important to understand that when I use the vernacular triggering conviction, I'm looking at Florida statute 322.28 subsection 2. The first sentence says, in a prosecution for a violation of Florida statute 316.193, which is the criminal DUI statute, or former 316.1931, which is the former Florida criminal DUI statute, the following provisions apply. In Florida, as in probably any other state, if you're convicted of DUI, you have now triggered a suspension. And the question becomes, what is the period of that suspension? Importantly, later on in the statute, there is an enhancement section. Immediately after section 2A3, there's an enhancement provision that allows for increasing the period of suspension if you have prior convictions, even from out of state. Notably, what's missing in this statute, in the first sentence, is any reference to an out-of-state conviction as being the triggering conviction. It simply alleges Florida convictions and nothing more. The interpretation that my opposing counsel, I'm sorry, Judge?
I have a question for you.
Okay.
What about I have really two. And the first one is, I think we can all agree that the second-tier certiorari standard requires more than a misapplication of the law. It requires a miscarriage of justice. So I want you to address the second-tier certiorari standard. But assuming that for purposes of the discussion that you're going to make a credible, colorable showing on that, what about 322.24, which says the department is authorized to suspend or revoke upon receiving notice, blah, 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 if committed in this state. And then your opponent has pointed out that we have to read 3.322.281 and 2 along with 0.24, which seems to support the trial court's interpretation. So those are two questions that I think go to the heart of your case, and let's hear about it.
First of all, with second tier certiorari, I cited to the Rose case, the Haskins case. If the circuit court applies the incorrect law, that satisfies the second tier certiorari jurisdiction, because applying the correct law incorrectly, you are right. That doesn't get relief. That's not a miscarriage of justice. But this court, the second DCA, both in Haskins, both in Rose, and there are many other cases out there from other district courts. When the circuit court applies the incorrect law, that in and of itself satisfies second tier certiorari.
Okay, so you're saying that by applying 3.322.28, the circuit court applied the incorrect law?
The circuit court misinterpreted the statute. The misinterpretation of the statute in allowing subsection 2 to apply to an out-of-state conviction, they interpreted the statute to allow for that. The statute does not allow for that. So they've misinterpreted the statute. Misinterpretation is the wrong law. And there's actually, there are cases out there that actually talk about statutory misinterpretation does satisfy second tier. It's the same as applying the incorrect law. So in now going to your second question, 322.24 certainly does authorize the department to suspend. It doesn't give any reference in terms of period of suspension. It just simply says if you get convicted out of state, you get a suspension, which means that they now have to come over to 322
or a revocation. I mean,
or revocation.
just reading 322.24 in its entirety. And then we look to 2.8 as the period of suspension or revocation. And subparagraph 1 says, except as otherwise provided, unless otherwise provided, the department shall not. And then it lists out the exceptions that are couched in section 2 in terms of prosecution. So where's the disconnect?
Disconnect is this. Subsection 1 is essentially a catch-all. If other portions of the statute don't identify the scenario, the maximum period of suspension is 1 year. So now that brings us to 322.28. The DMV is asking you to rewrite the first sentence of the statute to say, in a prosecution for violation of Florida DUI statute or the former Florida DUI statute, or any conviction from out of state. That language isn't there. And I think one of the key elements to the canons of construction, when you look later on in the statute where it specifically references out-of-state convictions to be used as enhancement, this court under the canons of construction must imply that or interpret the statute that the legislature engaged in intentional act by omitting any reference in the first sentence to out-of-state convictions. If they wanted out-of-state convictions to be the triggering conviction, it would have been in the first sentence. The fact that they put it later on in the statute means that they were thinking about it. So in the absence of that language being there, there is a huge disconnect. And what actually the DMV is asking you to do is bring in to play a statute 322.44, which they never noticed my client for. Both notices of suspension, the one in April and the one in July, specifically reference 322.24, 322.28. I don't have the statute 322.44, which is the compact on interstate driver's licenses. I don't have the exact language, but it essentially, the essence of it is if you get convicted out of state, it's as if you got convicted in Florida. That's the statute that the DMV needs to complete the argument. And certainly their absence of noticing my client that they were relying on 322.44 raises all sorts of
Isn't your client on notice of the driver's license compact by virtue of his status as a New York driver and a Florida driver?
I mean, I don't disagree. I mean,
I mean,
it's on the
when
books.
did ignorance of the law become a statutory misinterpretation?
It's
or a
on the
failure
books.
to
You're right, Your Honor.
acknowledge?
However, there's a very large body of law that talks about a proprietary interest in driver's licenses and the need for compliance with 14th Amendment due process considerations. And certainly procedural due process requires that my client be given notice. The DHSMV has locked itself into 322.24 and 322.28 and no other statute because they never noticed my client. Why would he have to prepare for a statute that they said we're not relying on? That is the essence and the foundation of the due process requirements, procedural due process requirements.
That you assume for purposes of making that argument, and we may agree or disagree with you on this, but you're assuming that 322.28 read together with 322.24 are not sufficient themselves to support the department's action. Isn't that an essential part of your argument against 0.44?
I agree. I absolutely agree with you. Without 322.44, my position is 322.24 and 322.28 do not connect. The period of suspension, when you apply the canons of construction, the absence of specific language allowing an out-of-state conviction to be triggering to get the enhancements under section 322.28 subsection 2, without an out-of-state conviction being a triggering conviction, they don't get the benefit of the 5-year enhancement, the 10-year enhancement. They don't get it. They're locked into the 1-year period of suspension that is the catch-all suspension under subsection 1. And they don't.
What about the holding of the first district in Silha with regard to 322.24?
Well, but Silha involved 322.26.
The court also said section 322.24 Florida statutes, which my understanding was the same then as it is now, authorizes the department to suspend or revoke of the license of any residence upon receiving notice, blah, 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 pursuant to these two statutes. And 2.4 is sort of standing in here the way it is in our case. The holding was that the department would have been entitled to suspend or revoke consistent with 2.4. So help me understand why your opponents argued that case is dispositive. So help me understand why it isn't.
Well, again, with all due respect, it's not dispositive because what happened in Silha, it's a combination, 322.24 and 322.26, and the period of suspension from 3.26. So that brings us back to the argument here. The period of suspension, and I agree, the period of suspension for an out-of-state conviction is going to be governed either by subsection 1 or subsection 2. There's no doubt 322.28 defines the period of suspension. 322.24 does not. It simply gives authority to suspend, and the statutes have to be read in paramateria. That's why the absence of the language in the first sentence of 322.28 subsection 2, not making any reference whatsoever to out-of-state convictions as being sufficient to trigger the enhancement portion, they're asking you to rewrite the statute and write that language in. The court, in the absence of the language, the plain meaning of the statute, having language that brings in as a triggering conviction the out-of-state for purposes of the enhancement in section 2, it doesn't matter how many convictions you may have from out of state, subsection 1 has to apply because, as I said again, and I'll concede, if they would have noticed my client for 322.44, then his argument would be totally different. We would be arguing whether or not the only argument he would have is whether New York complied with the requirements under 322.44. That's not before you. They never noticed him for that. So they're now locked into these two statutes and only these two statutes. And we believe that the canons of construction prohibit rewriting the first sentence of subsection 2, because it's specific. It makes reference and only reference to Florida conviction for DUI and nothing else. I would like to talk a little bit about an argument that opposing counsel raised in their response. That they talked about res judicata. I would like to spend just a couple minutes on that. I believe it's been waived. The hearing officer, who is Catherine Bischoff, she's a licensed attorney. About 4 years ago, the DMV went to attorneys as being the hearing officers. She's certainly a member of the bar. She's trained in res judicata. If we would have applied for this hearing and she said, no, I'm not going to give it to you, that would have been the end of it. But she took jurisdiction. And now, by raising res judicata on appeal, the DMV is essentially saying, we disagree with our own employee and her decision to take this. So because we disagree.
Isn't your best argument on res judicata that it's unpreserved?
Absolutely. Absolutely. Ms. Bischoff never raised it. She just simply took it. And then on appeal, they start to argue it. And I've said all along, it's waived. So
And we only get to res judicata if we are not fully buying what you're selling on the statutory interpretation issue. Am I right?
I don't disagree with you at all, Judge. I don't disagree with you at all. But I do want to make reference that I don't believe that res judicata is going to apply. I think that in this particular case, it's a very simple question of statutory interpretation. Does subsection 2 and its enhancements apply when the triggering conviction is out of state? Or is the DMV, because they failed to properly notice my client of 322.44, locked into the catch-all period of suspension of 1 year under subsection 1? And that's my argument.
And you're right at 15.
Thank you, Judge.
Thank you. Let me stop the clock from running. Interesting. Thank you. Attorney Jones, you may make your presentation.
Thank you, Your Honor. May it please the court, my name is Alana J. Jones. I'm an attorney with the Department of Highway Safety and Motor Vehicles. And of course, it is our position that the circuit court properly denied the petition for writ of certiorari below and determined that the revocation period was appropriate. As the panel pointed out earlier, in order to analyze the court's decision below, we have to keep in mind what the standard of review is. And of course, the standard of review being, did the circuit court apply or accord procedural due process? And was the correct law applied? Now, there was no due process argument as far as the circuit court violating due process. So really, our only argument we have here is whether or not, or the only consideration is whether or not the correct law was applied. And as stated earlier, it can't be just mere legal error. There has to be a violation of a clearly established law resulting in a miscarriage of justice. And of course, in order to determine whether a clearly established law was violated, we have to look at the statutes, examine the statutes that the circuit court examined, which are relevant in this case: 322.24, 322.28, and 322.44. The court had to look at what happened in this case. You have a Florida driver with 3 DUI convictions that took place in New York. All 3 took place in New York. And of course, what happens in that situation where we have 3 DUI convictions on a person's record? So the court had to go to 322.28 sub 2. And of course, for 3 DUI convictions, when a person receives a 3rd DUI conviction, and of course, the offense of which took place within 10 years of the prior DUI conviction, that licensee must be revoked for a period by the court for 10 years.
But by the plain language of 322.282, that only applies in a prosecution for a violation of 316.193 or former 1931, right?
Well, it would apply in a prosecution for that, but of course it goes on to state in that provision. And of course it references prior DUI convictions.
Sure, and there's no question that the prior DUI convictions
Mhm.
can be from out of state. I
Right,
mean, there's absolutely no question about that.
that's correct.
But by its plain language, that provision applies only in a prosecution, an instant prosecution.
And if,
Presumably, there is no prosecution whatsoever here under 316.193, correct? There never has been?
because it happened out of state, Your Honor, it happened out of state, but when,
Okay, that's fine.
right,
That's fine, but there is no prosecution under 316.193, right? That's beyond question.
well, Your Honor, this is where we have to
No,
look at,
it's yes or no. There's no prosecution under 316.193.
because it didn't
right.
take place in Florida, these took
Right,
place in
but
New York.
the answer is
Of
no.
course, right.
Okay,
So of course, because they took place in New York. But this is where we have to read these statutes in pari materia to one another. We have 3 DUI convictions that took place in New York. Now, of course, what do we do with that? And of course, as has been stated earlier by the panel members, as was pointed out, 322.24 gives the department the authority to revoke when we're put on notice of a DUI conviction or a conviction from out of state, to revoke or suspend when that DUI conviction or that conviction, if it occurred here in Florida, would result in a revocation or suspension here. And this is what happened in this case. We have a DUI conviction, a 3rd DUI conviction, which took place in New York. If that had happened here, it would have been a revocation here. So we have the authority as the department to revoke in that
So
instance.
basically your read, if I'm following you, is that under subsection 1 of 2.8, unless otherwise provided by this section, the department shall not suspend for more than 1 year. And you're reading the unless otherwise provided to mean that we should read section 2 to encompass the department's authority, even though it says in a prosecution for, as opposed to the department may.
Right, yes, we have to read these 2 together in order to get the authority or to understand why the department is able to revoke in this instance. Because yes, it does say in a prosecution for 316.193, but then you have 322.24 that states, if we have a revocation that took place or that's reported to us from another state, that if it had occurred here, the offense had occurred here, we have the authority to revoke. We have that authority to go ahead and do that in Florida. Now, what's also the case, 322.44 must be read along in pari materia with these other 2 statutes as well. Now,
so basically you're saying that the department has the authority to stand in the shoes of a sentencing judge. That's the equivalent.
by virtue of, yes, ma'am, by virtue of 322.24, that gives us the authority to do that. Once we are.
So does the defendant get a trial with all the attendant due process protections that they would get in a criminal trial before a sentencing judge?
Well, Your Honor, we stand in the place in the sense that we have the authority to revoke. Of course, we're not a court. There is an administrative component that handles hearings, but generally speaking, the department is not a court. But we have the power to revoke just as the court would have the power to revoke under 322.28. If
you basically have, the department has the ability to impose a criminal penalty without any of the attendant due process considerations that would go into a criminal prosecution.
Well, actually, Your Honor, this is not a criminal penalty. A revocation of a license is not a criminal penalty, but it's an administrative remedy to ensure the protection of the public.
Right, but a prosecution under section 316 would be a criminal prosecution in front of and there would be a sentencing judge?
There would be in that instance, of course, with regard to the sentencing. But the court has the power to revoke under 322.28, but the department also has the power to revoke under 322.24 in this instance. So we're not pursuing a criminal proceeding.
Let me ask you a question then brings up a point that your opponent has raised. In your briefing, you rely on 322, the driver's license compact, 322.44.
Yes, ma'am.
And Article 4, essentially for the full faith and credit argument to bridge whatever gap there might be. Is that a fair characterization of the argument that you make?
Yes, ma'am. That we
Okay.
are arguing that they should be read in peri material.
Okay, and your opponent makes the argument that 322.44 was not apparent in the notice document, that he's been deprived of due process because of it. What's your response to that?
Well, my response, Your Honor, would be, first of all, this wasn't an argument that he raised in his petition. So for the first time in his reply, he raises this argument. And of course, the court in Department of Highway Safety Motor Vehicles versus Sperber states that you can't raise your argument for the first time in a reply.
Well, was he replying to the argument that you made in your answer brief? Because if he was, I'm not sure your waiver argument holds up.
Well, Your Honor, respectfully, we believe it would hold up because this wasn't a surprise to the opposing counsel because this argument was raised below.
So you're saying he knew and needed to brief whatever due process arguments he wanted to make when he filed his petition?
Absolutely, Your Honor, because this was an argument that we made below in the circuit court. And the circuit, I'm sorry.
Let me just be clear. I want to make sure I understand. Your argument in the circuit court was that you relied in part on 322.44 for the correct what you are the beneficiary of the trial court's interpretation or the circuit court's interpretation of the statute.
Yes,
Okay.
that was part of it.
So having done that, your position is that he was bound to raise the due process argument around 4.4 in his petition or not do so under pain of waiver.
That's correct, Your Honor.
Okay.
That is our position. And also, furthermore, Your Honor, it's our position as well that 322.44 wasn't required to be listed in that initial notice to begin with. And we cited to the Brown v. State case where it held that a criminal information didn't have to contain every reference to every legal authority with regard to sentencing, but the person had to be, or the defendant had to be properly apprised of the offense of which he was caused, of which he was charged, excuse me. Likewise, in this case, our notice needed to apprise the petitioner of the reason why he was being revoked for 10 years. And he received that appraisal in that notice, and the notice that took place on July 11 of 2019. So he received that notice. Furthermore, Your Honor, he's raising this due process argument. The petitioner is that, oh, my client's due process rights were violated, so on and so forth, by the department not properly noticing us. However, this is talking about what happened at the administrative level. What we're reviewing here is what the circuit court did. Did the circuit court apply the correct law? Did the circuit court violate due process? And there was no due process argument raised with regard to the circuit court's handling of this case. We simply have an argument concerning what was the correct law that should have been applied. And we believe that all three of these statutes, 322.28, 322.24, and reading in peri materia with those two, 322.44, that the appropriate revocation period would have been 10 years because the driver license compact, of course, is an agreement with member states that a revocation or conviction in another state will be treated by the home state as if it happened in the home state. And specifically in Article 4 of that section, it states that the licensing authority of the home state for purposes of suspension, revocation, or limitation of license shall give the same effect to the conduct reported pursuant to Article 3 as if it would if such conduct had occurred in the home state. So here we have a person who has 3 DUIs, the third DUI takes place. Now we're invoking 322.28. 3 DUIs, what happens in that instance? We look at 322.24. The department has the authority to revoke if we receive notice of a revocation from out of state. Then when we look at 322.44, which mandates that if we receive notice of an infraction occurring outside in an outside jurisdiction, we are to give the same effect to that conduct as if it had occurred in Florida. So we don't have this issue of, oh, we have this out-of-state conviction and it can't invoke any type of suspension on my client's part. No, that's not the case, because the compact states that if it happens in another state, we have to give it the same effect that it would have if that conduct had taken place in Florida. And of course, what happens when you have a third DUI conviction that takes place within 10 years of the last DUI? What is the effect of that conduct? A 10-year revocation. So that is the appropriate revocation in this case. And we believe that the circuit court appropriately denied the petition for writ of certiorari and determined that that 10-year revocation was absolutely appropriate. And with regard to res judicata, we do believe that this case would be barred in res judicata, as was stated in the brief. We believe the circuit court was generously considering this matter, but this matter was, there was a prior administrative hearing where these issues were raised or could have been raised, and they were not. And it states in Turcotte versus City of Coconut Creek, res judicata bars an appeal when the lawfulness of an administrative action was determined on the merits and denied. And that's what happened in the first Moliterno case. And this doesn't apply when the same issues are raised, but if the issues could have been raised at that time.
Where did the department make that argument in the circuit court in this case?
I believe we did make that, Your Honor. We stated that there should have been, I would have to pull up our response, but this argument would have been made because we.
So you're saying your opponent's argument that that res judicata is unpreserved is unsupported by the record.
I believe we did raise this argument, Your Honor. This argument was raised because this was something that was decided or was raised. This case, basically the same issue came up in a separate case. And
your position is you argued that to the Circuit Court Appellate Division?
Yes, I believe we did, Your Honor. I believe we did do that. And unfortunately, and the court in its wisdom decided to go ahead and hear the merits of the case, but we did raise it, but they went ahead forward and ruled on the merits. And we believe they ruled correctly on the merits, but actually they didn't have to because of what happened. Because of what happened in the previous case. And furthermore, with regard to our not raising res judicata at the administrative level, you have a hearing officer who, while she is an attorney, she is supposed to be an impartial arbiter of the facts. There is no attorney representing the department at the administrative level. So as a result, that issue wouldn't have been raised at that point. Furthermore, Your Honor, we have the right as the respondent to raise any issues, which if there's support of which in the record, we can use that as a defense to defend our position. So I believe it's absolutely appropriate for us to raise that issue at this point. But based substantively on the law, reading the statutes, comparing material with one another, we believe that the circuit court correctly determined that the 10-year revocation period was the appropriate revocation for the petitioner in this case. And secondarily, we do feel that res judicata really prevents this case from going forward in the first place because there was a prior case at this time. And as a result, we respectfully request that the petitioner's petition for writ of certiorari on second tier review be denied.
Thank you, counsel.
Honor, may I go forward?
Trying to clear the time, you only get 5 and it's like at 18, that would say that you're over. So let me clear the machine.
Oh,
To make
okay.
sure you get it. You know,
Okay.
technologically challenged.
I'm sorry, Judge.
Okay, it's all clear. You may proceed.
Thank you, Judge. I respectfully disagree with some of the comments that my opposing counsel made when she talks about giving the same effect as if the conviction from New York occurred in Florida. That's language that comes from 322.44. There is no effect language in 322.24. It just simply says there's authority. If you get convicted, if they get notice of a conviction from out of state, there's authority to suspend. Nowhere in that statute does it say you give it the same effect. And so again, that brings us back to 322.28. And when we look at second tier relief, if the circuit court definitely applied subsection 2. If the applicable section is section 1, it applied the wrong law. It didn't apply the correct law incorrectly. It may have applied the correct statute, but it applied the incorrect section of the statute. That's the application of the wrong law that entitles us to the necessary jurisdiction. And I think that we need to point out here what the department is asking this court to do is to violate a very, very primary concept in statutory construction. That is the presumption against ineffectiveness. The way that they read the statute and the way that they're interpreting it by trying to step into the shoes of a Florida conviction essentially makes section 1 meaningless. It gives it no effect whatsoever. And that certainly violates the presumption against ineffectiveness, which I cite to, that comes from Scalia and Garner. So her interpretation, or the circuit court's interpretation, violates a very, very primary premise. And I would like to point out one other issue, because Judge LaBrette, you've made reference to 322.281. There is some language in there that you're referencing after it gives a period of suspension of 1 year and upon revoking the license in any case except in a prosecution. All of that language in that part of the statute, when you read the last sentence, says shall not in any event grant a new license until the expiration of 1 year. Everything in that statute after the 1 year period of suspension is saying you don't get a hardship license. It's defining what circumstances, in some circumstances you get suspended for a DUI and then you're entitled to a hardship license. They're simply saying if you fall under this 1 year revocation, you don't get a hardship license. That's all that's saying. This is subsection 1 is nothing more than a catch-all phrase that says if no other section in this statute applies, you get a 1 year suspension. And so going back to my point, subsection 2 is all about an in-state conviction for DUI triggers a suspension period. An out-of-state DUI conviction triggers a suspension period the way that we read the statute, and we think that the circuit court misinterpreted this as being should have been subsection 1. And I think where the mistake happened, when you read the circuit court decision, they relied on the enhancement section of 322.282. They saw a reference to out-of-state convictions, and that out-of-state conviction can enhance, but it doesn't qualify as the triggering conviction. And that's where the circuit court, I think, fell into its mistake. It allowed the out-of-state convictions to stand in as a triggering conviction and give application
The
to the
court
enhancement.
also relied on the interstate driver's license compact and did so in that section of the opinion.
They did.
So
and
the only way we get to where you want to go is if we accept your argument that your client wasn't specifically charged or notified of the applicability of the compact.
And like I said, there's a very large body of law. There's Montree versus Macomb. Bell versus Burson. There's the Hoffer case, which is out of your decision, that talks about proprietary interests in driver licenses and the application of 14th Amendment procedural due process requirements. And that includes notice. And that is as fundamental to 14th Amendment procedural due process notice. And the only notice my client got was 322.24 and 322.28, no reference to 322.44. And that falls on the department's shoulders. That falls on their shoulders. So for those reasons, we ask that you grant this petition to second tier certiorari. I thank the court for its attention.
Thank you. Thank you both. Well presented today. We very much appreciate it. Hoping that you know how to go back to your way station. You are more than welcome to sit and watch the last case on the docket if you wish, or get around the rest of your business day. Thank you and stay well, please.
Thank you very much. You do the same, Your Honor.
Thank you.